comes to dealing with the sort of multiple intersectional issues of class and race and other inequalities that I've just outlined to you. A key problem in this framework is that the legal standards dealing with class and socio-economic related issues more generally tend to be structured on different lines from the legal standards relating to equality and non-discrimination. Okay? They tend to operate, as a generalization, on different tracks. Oops. They tend to operate on different tracks. Okay? Now, that poses problems when it comes to making use of these legal frameworks to challenge government action that involves discrimination on intersectional grounds of race and class. It also can limit political action when people try and start appealing to resources and human rights law and law more generally to make political claims. The separate socio-economic equality lens through which the law tends to view these issues can actually, how would I put it, dissipate energy, or at least result in a lack of the sort of unified focus on intersectional issues that's so urgently needed. So that's why my presentation, why I've entitled it Socio-Economic and Equality Rights on Parallel Tracks. Now, I'm going to finish by being a little bit more optimistic in showing you how there can at least be a certain degree of overlap or convergence between these different tracks in certain circumstances. But that's just to explain the title of my presentation. We'll start talking about equality standards. Now, in contrast to the relatively limited protection given to socio-economic rights, UK law is quite strong, at least comparatively speaking, when it comes to protection against discrimination on what we tend to call classic non-discrimination grounds, race, gender, disability, and so on. Okay? But its strength in this respect is relatively narrow. Okay? If you can bring a clear claim of direct race discrimination, of indirect race discrimination, and so on, you will often find lawyers who will be able to bring that case for you. You will often be able to frame it in a way with some chance of success. Okay? And you'll often find public authorities in particular are very jumpy at the notion of being subject to a race discrimination claim and may very well be prepared to settle in a way favourable for the people you're representing or the interest you're trying to protect, in a way that they mightn't be so quick to settle in other circumstances. You know, race discrimination, if you're a lawyer, an accusation, a reasonably credible accusation of race discrimination, for example, is a powerful thing to put into your letter to Camden or whoever, saying you need to change your behaviour. Okay? But in other words, UK equality law is a powerful tool, but one of relatively limited scope of application. Equality Act 2010 prohibits discrimination on a number of different grounds. They're the key grounds. Okay? You will notice class, socio-economic status is not there. Okay? In some other countries, anti-discrimination legislation also covers class or something equivalent, like socio-economic status. Interestingly, it tends to generate relatively little case law, often because people aren't quite sure what exactly discrimination on grounds of socio-economic status or class grounds is. We might talk about that a little bit further in questions, but but it's certainly in any case not a ground which you can bring a challenge directly in UK anti-discrimination law. The 2010 Act, I should have mentioned it, of course, also imposes the positive equality duty on public authorities, the duty to take action to eliminate unlawful discrimination and to promote equality of opportunity on those grounds. Okay? A potentially powerful tool, okay? Potentially powerful tool to pressurise public authorities to do better when it comes to discrimination issues. But as with other elements of equality law, if you're trying to challenge intersectional issues involving the intersection of class and race or gender and and gender and class, or disability and class, or religion and class, then you have to come at those issues through the equality non-discrimination lens primarily. You need to find an issue of race discrimination, for example, or an issue of inadequate opportunities for particular ethnic groups, and use that to try and challenge a pattern of socio-economic exclusion. Let me give you an example. There's been lots of interesting litigation recently on the bedroom tax. Okay. Really familiar with the bedroom taxes. And actually, the challenges to that have been quite interesting because they've come in usually on a gender discrimination, disability discrimination line of attack. A failure to take into account the vulnerabilities of particular groups, in particular female victims of domestic violence, carers, people with special care and responsibilities, persons with disabilities, or persons with disabilities who need special provision, living carers, carers asleep overnight, and so on. And legal challenges using indirect discrimination requirements have been quite effective, relatively effective, at sort of carving out certain exemptions from the bedroom tax rules. Okay. But again, you're sort of confined to attacking around the sides, so to speak, to using the narrow lens of anti-discrimination law and to try and extracting its maximum potential if you want to seriously challenge intersectional issues involving race, class, disability, class, and so on. Okay. Section 1 of the 2010 Act, Karima mentioned, would have imposed a positive duty on all public authorities to take into account the impact of their policies on poverty and inequality. Okay? That was a reasonably general positive duty, weaker informed than the more specific positive equality duty. It nevertheless, in my view, would have been an interesting and progressive attempt to try and include a sort of socio-economic class dimension to the existing anti-discrimination legislation. It's never been put into effect. It needs a ministerial order to trigger it. The coalition government 2010-2015 took the decision not to trigger it. The current government has said it won't trigger it. Okay? So it could be triggered by, for example, a future Labour government, but it needs some active ministerial decision to make it or make it right. Okay? And if you're curious as to how an act of Parliament can be nullified by a minister just choosing not to implement it, welcome to the wonderful world of the British Constitution. Parliament can be sovereign, but can be very easily nullified by a little provision saying, you know, something has to be triggered by ministerial declaration. But in general, we have UK law doesn't deal well with issues of race and class, intersectionalism. Okay? Indeed, another aspect of the Equality Act 2010 that was supposed to be brought into effect was the provision that would have allowed multiple discrimination claims to be brought on an intersection of two grounds, race and gender, for example, or disability and race, and so on. That also was not brought into effect. You may be noticing the recurring theme here. So UK law has been kept very much in its binary approach. Strong but narrow anti-discrimination protection, very, very weak socio-economic rights protection. Primarily fed out through social welfare legislation, lacking much in the way of strong constitutional human rights protection. You do have some overlaps, and with clever campaigning, clever lawyering, you can use, for example, the Human Rights Act to tackle some intersectional issues, in the same way you can use anti-discrimination law to tackle some intersectional issues. UK law remains firmly committed to having a very, very limited socio-economic rights dimension and having strong equality protection, but only applying it in narrow scope. Things may change. And there's interesting discussions globally about making socio-economic rights legally enforceable. There's interesting discussions about trying to have a socio-economic rights dimension to equality. Section 1 of the 2010 Act, while quite limited in some ways, the positive equality duty in relation to socio-economic grounds, that would have been an interesting first step. So things may change. There are interesting debates globally on this issue, but for now, UK law remains circumscribed and confined. You need to be highly tactical campaigning, highly tactical use of law if you're going to really get to grips with these pressing issues of race and class that confront us every day. Thank you very much.